Hi, welcome to Commercial Law Tutorials. Under the topic Law of Contract, we have covered the definition, formation, and the essentials of valid contract. Today we are moving on. We are going to look at offer and acceptance in detail. In this lesson, I'm going to define what an offer is and also what acceptance is. Then the requirements of a valid offer, termination of an offer, requirements of a valid acceptance, theories of acceptance, and lastly, we will look at questions relating to this topic. Now let us define an offer. An offer is a proposal which expresses a person's willingness to become a party to a contract according to terms expressed, and the acceptance by another person binds both of them contractually. Remember, offer plus acceptance is equals to a contract. When one gives an offer and the other party accepts that offer. In this lesson, we are going to use the words offerer and offeree. I will explain what an offerer is. An offerer is the person making the offer. Then the offeree is the person accepting the offer. Now, the general rule regarding offers is that a contract is concluded the moment that an offer is accepted, provided the other essentials of a contract are present. Remember, the essentials of the contract we have covered in the previous lesson. So, the essentials of a valid offer are that there should be serious intention to contract, offer must be communicated, offer must be definite, offer must not have been revoked, offer must be one on which an optional time limit has not expired. For an offer to be valid, it should contain all these essentials. So we are going to move on now. I'm going to look at this in detail. First of all, we'll look at serious intention to contract. An offer must be firm and must truly mean business. The offerer must not simply make a tentative statement of willingly to do business, but must make his offer specific with the intention to create a contract. Offers made jokingly do not form a contract. The offer must have the intention of being accepted and not a mere invitation to do business like in adverts and window displays. An incomplete offer which leaves certain terms to be discussed at a later date does not lead to a binding contract. As it happened in the case of OK Bazaar versus Bloch. There were prolonged negotiations for the sale of shares. One of the parties suggested that they had argued over the matter for too long and said, let the two attorneys wrangle between themselves as regarding to terms. There was no mention of payment or price, and the mode, that is the basic elements, were missing. So it was held that the bargain was not final and complete. There was no contract at all since terms had not been defined, which make up the contract. The second essential of a valid offer is offer must be communicated. An offer must be communicated to the offeree, whom it is intended that contractual relations should arise. The general rule is that offer has no force or effect until the offeree knows of it. Offer may be made to a particular person, a group of persons, or to the whole world. If an offer is made to a specific person, it cannot be accepted by another person, that is a third person. An offer made to the whole world may only be claimed by the first person to do the required act, as in the rewards cases. The first person to act accordingly will be entitled to the reward provided he was aware of the reward and asks for that reward. Then, third essential is that offer must be definite. The offer must not contain vague statements that the other party cannot understand. A person accepting the offer should be aware and should understand all the terms of the contract for it to be binding on him. There can never be a contract when parties have different conflicting intentions in the contract. So, offer must not leave aspects of agreement to depend upon the future will of the parties. Offer should also not leave parts to agreement blank or open to subsequent negotiations. And offer should contain wording which is not vague, unless the vagueness can be clarified either by checking facts or applying the test of reasonableness. So that was it on offer should not be vague. Next, we have offer must not have been revoked. Offer may have been revoked or it could have lapsed in one of the following ways. Offeree is notified that it has been revoked. Either the offerer or the offeree dies. Lapse of reasonable period of time. Supervening impossibility or illegality. Rejection is where the offeree makes a counter offer which contradicts the original offer by proposing specific alterations to the terms of that offer. Then next we have offer must be one on which an optional time limit has not expired, that is nadam term. When time with a specific deadline, that is the optional time limit, has been given to a particular offeree for consideration of an offer, such offer lapses when the deadline is reached. Options can be given in respect to different kinds of contract, for example, the contract of sale or the contracts of lease. So let me now explain to you how the optional time limit works. First of all, the option giver makes an offer to enter into a particular contract, that is the substantive offer, that is the main offer, and in addition makes a further offer to keep the first offer open for a specific period, the second offer being the option. The offerer is bound to keep open the substantive offer for the agreed period. This means that for the duration of the agreement period, that is the duration of the option, the offerer may neither revoke the substantive offer nor may he enter into a contract with another person concerning the same subject. When acceptance is given within the option, the contract comes into being in accordance with the terms contained in the substantive offer. Now, how is an offer terminated? Offer is not intended to remain open indefinitely. Offer is terminated by the following, and offeree cannot accept the offer if it is terminated. Firstly, the expiration of fixed time, that is the nadam term we have been talking about. Offer made for a specific period of time, and when that fixed time has lapsed, the offer ceases to exist. This happened in this case. In January 1948, Stone wrote to Rage stating that he was prepared to buy certain shares from Rage on 13th of April 1949 at a stated price. In February 1949, before Rage had accepted this offer, Stone purported to withdraw. Rage wrote accepting the offer. It was held by the court that because the offer was for a fixed time, it was irrevocable within that time, and acceptance was therefore valid, despite the withdrawal. Now the second one is expiration of reasonable time. When the offer has no fixed time to remain in existence, the offer expires in a reasonable time. The court can help decide what is reasonable and unreasonable, taking into account all circumstances surrounding the case. This happened in this case, where a document was drawn up on 1 November 1907, and the court held that an offer to sell land on 1 November 1907 could not be accepted in February of the following year. To turn an offer into a contract, the offeree must not only accept, but acceptance must be communicated to the offerer within a reasonable time after the offer has been made. So acceptance was made too late. Then offer can be terminated also by revocation of offer by offer. Offer may revoke his offer at any time before acceptance has taken place. The revocation is ineffective until brought to the knowledge of the offeree or his agent. The manner in which the offeree comes to know of it is irrelevant unless there was an express agreement. Maybe they told each other that in case that the offer will be revoked, it will be revoked through telephone. So telephone should be used in revoking that offer. For example, in this case, on the 6th of June, Whitcroft signed a written offer to buy certain land from Greenberg, the owner. On 7 June, Whitcroft telephoned Greenberg's agent, revoking the offer. And on the 8th of June, Greenberg signed an acceptance on the documents containing the written offer. It was held that the offer had been effectively revoked on the 7th of June and was no longer open for acceptance. Then the other thing which can also terminate an offer is a counter offer. Counter offer just destroys the original offer. For example, the agreement on reducing offer price or changing some of the contractual terms and conditions. For example, in this case, Reg offered to sell his farm to Hyde for £1,000. Hyde immediately made a counter offer of £950. Reg considered the matter for some time and then advised Hyde that his counter offer was not acceptable. Hyde thereafter purported to accept the original offer of £1,000, but Reg was no longer interested. Hyde's counter offer had destroyed Reg's original offer, which could not thereafter be accepted. Now, the other way of terminating an offer is mode of acceptance. If offer prescribes the mode or method of acceptance, in this situation, any other way or mode of acceptance will not create a contract. For instance, in this case, an offer by Eliasson to buy flour from Henshaw was brought to Henshaw by Wagon. In the terms of the offer, it was required to send his acceptance to Eliasson by means of the Wagon. Henshaw, thinking he could reach Eliasson more quickly by post, accepted by letter, which arrived after the Wagon. It was held that the acceptance was invalid and there was no contract because the acceptance had come using the wrong mode of acceptance. Next, rejection by the offeree. An offer comes to an end if rejected by the offeree. The offerer is free to go and contract with other persons. 7. Reward cases. An offer which is open to the whole world, but which can only be accepted by one person, lapses when the first person accepts. Then we have death of either the offerer or the offeree. Next, insanity of either the offerer or the offeree. Then offer becomes illegal or impossible. First of all, we want to define an acceptance. Acceptance is the assent by the person to whom the offer is made to be bound by the terms contained in that offer. Then the essentials of a valid acceptance. Before an acceptance can turn a valid offer into a contract, the acceptance must be made during the life of the offer. Acceptance must be in the terms of the offer. If it is subject to conditions, it is not also acceptance but a counter offer. Acceptance should also be consistent with the essentials of a valid contract. Acceptance must be lawful. Acceptance must be made within the limits of the offeree's contractual capacity. Acceptance must be serious and made with the intention that a contract should be created. Acceptance must be communicated to the offerer. Acceptance must not be vague. Acceptance must be made with both parties of the same mind as to the subject matter. If you want to understand this more, visit the essentials of a valid contract. They are explained including the cases. Now, acceptance also should be possible of performance. Then next, acceptance should be in the manner prescribed by the offerer. The manner in which acceptance is to be made may be expressly prescribed by the offerer. If the acceptance is not made in the manner prescribed, there is no contract. For instance, the case we have it before, where the offeree was told to accept using a wagon and he accepted using a letter which arrived after the wagon, and the court held that there was no acceptance was invalid, there was no contract because the mode of acceptance used was not right. Now let us look at the theories regarding the completion of an offer and acceptance. We have the declaration theory. The theory states that the contract comes into being at the time and place where the offeree gives expression of his acceptance. For instance, written acceptance even though it has not yet been dispatched. Then the next theory is expedition theory. Contract comes into being at the time and place where the offeree sends the acceptance. For example, posting a letter of acceptance. Then the reception theory. It says that contract comes into being at the time and place where the offerer receives the communication of acceptance at the offerer's address, even before it has reached his mind. Then the information theory. The contract comes into being at the time and place where the offerer learns of acceptance. Next, let us look at acceptance by letter and telegram. The expedition theory applies. Contracts comes into existence when and where the letter of acceptance is posted, provided that all the other essentials are present. Where written acceptance follows a written offer, acceptance is valid at the time of posting. Where written acceptance follows an oral offer or option, acceptance is only valid upon receipt regardless of the distance between the parties. But where offer has demanded some other form of acceptance, written acceptance is void. By posting the letter of acceptance, the offeree leaves the risk of delay or loss to the offerer. The expedition theory applies. If the letter fails to arrive, there will still be a valid contract provided the letter was not incorrectly addressed by the offeree. Acceptance to a wrong address due to the offerer's fault is valid unless the offeree knew or suspected without checking. But where the mistake is the offeree's, acceptance is void. Acceptance to the correct address where the offerer has left that address without notifying the offeree is also valid. For instance, grant applied by letter for 100 shares in the insurance company, paying a deposit of 1% per share and agreeing to pay a further 19 cents per share within 12 months. The shares were duly allotted, but the letter of allotment went astray in the post and never reached the grant. The company went into liquidation and the liquidator sued for their unpaid balance on the shares. It was held that as soon as the letter of acceptance is delivered to the post office, the contract made is complete and final and absolutely binding, as if the offeree had put his letter into the hands of a messenger. So the post office here is working as an agent for the offerer, both to deliver the offer and to receive the acceptance. That's what the court said. So there was a valid contract. Next, we'll look at acceptance by telephone. The information theory applies here. The general rule is that an acceptance has no effect until it is communicated to the offerer. Hence, the acceptance must be communicated to the offerer. The information theory applies, and sometimes the reception theory, in which a valid contract comes into being when and where the acceptance is received. If a bad line exists which prevents the offerer from hearing the acceptance, then there is no legally binding acceptance. Now the questions regarding this lesson. Explain the essentials of a valid offer. An offer can be terminated in various ways. Identify and explain these. What are the essentials of a good offer? Briefly explain the reception and expedition theories of acceptance. Thank you for watching. Remember to subscribe if you haven't done so that you won't miss any other videos I post on this channel. Also like and comment.